everyone. Good afternoon. Welcome to our webinar. Today our topic will be on employees' right to self-organization. Our speaker will discuss key points of the session, and later on, after this, you as viewers, if you have questions, we encourage you to just type it in and we'll read it after the discussion. To introduce you, our speaker for today, she's from Kisumbing Torres Law Offices. Everyone, please welcome Attorney Ro Anuncio. Hi, Attorney.
Hi, Kate. Thank you for the introduction. Good afternoon, everybody. As Kate mentioned, I will be discussing the workers' right to self-organization, which is a right that is embodied in our Constitution and in several other laws, including the Labor Code of the Philippines, the Omnibus Rules implementing the Labor Code, and other regulations issued by the DOLE, the Department of Labor and Employment, particularly DO 4003. Just to give you an overview of what we're going to discuss for today, first I'll give you a general background of unionization in the Philippines. I'll also discuss the modes of union formation and registration. We'll also discuss recognition of union as a collective bargaining agent, how the processes go, and what they need to comply with in order to do that. The three modes, which are voluntary recognition, certification election, and consent election. We'll also give you a brief idea of what the rights of a legitimate labor union are and the corollary obligations of the employer with respect to the rights of the union. We'll also discuss collective bargaining and the right of employees to hold strikes and the right of the management to conduct a lockout. Grievance machinery, the formation of labor management councils, some unfair labor practices which are committed by both the employer and the labor organization, the modes of cancellation of registration of the union, and some pending bills on the unionization and collective bargaining. By way of a general background, the Constitution provides that all persons employed or all employees shall have the right to self-organization and to form, join, or assist labor organizations of their own choosing for purposes of collective bargaining. This right is embodied in the Constitution, in the Labor Code, in the rules implementing the Labor Code, and also in the issuances rendered by the DOLE and by other labor agencies. This right covers all employees in the private sector and those in the GOCCs without original charter. Just to give you an idea how union membership is at the moment, here is a status or here is the status of union membership, which provides for data from 1995 until 2014 during the survey conducted by the PSA. In 1995, as you can see, there's 30.5 rate for the union membership, which continued to decline until 2014. As of 2014, we have 7.7 on the statistics. This only means that union membership is continuously declining, and there is no point in history as of these statistics that the union membership actually increased. It's continually declining, and we believe that until now it continuously declines. Because of this information, the Philippine government has undertaken certain steps to encourage employees to join or form unions in business establishments. There are several reasons that are said to be behind this decline in union membership. For one, the employees do not see the value of joining a union. Why? Because employees nowadays, they usually get the benefits and pay that they actually deserve under the law. The statutory minimum, they get that already, plus other benefits that are voluntarily granted by the employers. They do not see any value in joining the union. Number two, they do not feel the additional benefits that they would supposedly derive from a CBA that is concluded between the union and management. Why is that? Because under the CBA, assuming they get additional salaries or additional benefits, that is actually offset by the union dues and agency fees that they are supposed to pay. Because as you know, unions are actually entitled or they have the right to offset from the salaries of the member employees or even the non-member employees who are covered in the bargaining unit, they're entitled to offset their salaries for the union dues and agency fees. So the additional benefits and additional pay that they get from the CBA, those are reduced because of the fees that they need to pay for the union. The third reason is that the unions and federations have earned a bad image and reputation through time. So I don't know if most of you have heard of, have seen the news or have heard of rumors, at least, that there are corrupt officers of unions or corrupt officers of federations who use the funds of the union or of the federation to fund their personal expenses. For instance, they have personal travels abroad that they supposedly would say are seminars that they need to attend in behalf of the union, but would in fact be personal travels, and then they would use the union funds or the federation funds for that purpose. But of course, they would deny that. But that's a rumor that would effectively affect the desire of the employees to join a union. So let's go back to the basic first. How are unions formed and how are they registered? So there are two modes of union registration. So union formation, it's just you gather a set of employees to form a union. But after forming a union, of course, you can't do anything with that without registering. So there are two modes of registration. There's an independent registration, which requires the 20% membership of the bargaining unit. So in this case, a group of employees who desire to form a union, they would have to garner the 20% support, the support of the 20% of the membership of the bargaining unit that they seek to cover in order to register the union in the DOLE. So in that case, they would file an application for union registration and attach therewith a copy of, let's say, the signatures. Usually it's like a petition, signatures of at least 20% of the members of the bargaining unit. Second mode is by chartering. So in this case, you need a federation or a national union to issue a charter certificate in favor of that local chapter or union. So in this case, they don't need a 20% membership requirement. They don't need to meet that. They just need a charter certificate from the federation. And in this case, it would be easier for them because they don't need to convince at least 20% of the bargaining unit. So who may join the unions? First, primarily, managerial employees cannot join or form or assist any labor union. And why is this so? Managerial employees are supposedly meant to protect the interest of the employer. So if they will join or form a labor union of their own, that may pose some conflict of interest on their part and on the part of the employer. Senior rank and file employees may join, assist, or form a labor union. However, they should have separate labor unions. So supervisory employees cannot join the labor union of rank and file employees and vice versa. But the union of supervisory employees and the union of the rank and file employees may be affiliated with the same federation or national union. So once a labor union is already registered with the Department of Labor and Employment, they already have a juridical entity. But after that, they are not yet certified as the bargaining agent of the employees within the bargaining unit that they seek to represent. So that means they cannot engage in collective bargaining negotiations yet with the management, and they cannot represent the employees in the bargaining unit as of yet. So in order to do that, they need to be recognized as the collective bargaining agent. And how do they do that? There are three modes in which they can be certified as the exclusive bargaining agent of the employees. First is by voluntary recognition of the employer, which happens very rarely. Second is by certification election, and third is by consent elections. First, let's discuss the voluntary recognition by the employer. So this voluntary recognition is a process by which the labor organization is recognized by the employer voluntarily as the exclusive bargaining agent. This is only possible if there is only one legitimate labor organization operating within the establishment for that specific bargaining unit. Because if there are two or more contending unions or labor organizations for a specific bargaining unit, the employer cannot make the decision in behalf of the employees and choose which labor union the employer would want to recognize, because ultimately the right to choose that labor union belongs to the employees and not to the employer. So this is only possible if there is only one labor organization. Upon voluntary recognition, there is a 1-year ban for a petition for certification election. This means that, assuming that the employer recognizes a legitimate labor organization at this point, no petition for certification election may be held within a year after that recognition. This means that within that 1 year, that recognized legitimate labor organization is at peace that no other labor union may take its place. So after that 1 year, that's the time that they can petition, that the other labor unions can petition for a certification election. However, that 1 year may be extended if there is already a registered collective bargaining agreement between the management and the recognized legitimate labor organization. So in that case, other unions will have to wait for the expiration of the concluded CBA, which is, since CBAs have effective validity of 5 years, so they have to wait for the freedom period um, before filing a petition for certification election. So when you say the freedom period, this refers to the last 60 days of the 5-year validity of the CBA. So they have to wait for that before they can file a petition for certification election if they want to be a contending party during the certification election. I think the voluntary recognition option is also prone to abuse, especially if there is an allegation of, for instance, a legitimate labor organization, a registered labor union that is actually in favor of the interest of the company or of the employer. So there may be allegations of um, preventing other unions from entering into the picture or from representing the other employees because let's say the employer recognized this labor organization that is actually protecting their interests and not the interests of the employees. Another mode for unions to be certified as exclusive bargaining agents is by virtue of a certification election. So this one, there is supposed to be a petition to be filed by the union with the BLR or with the DOLE. They have to file a petition for certification election attaching certain requirements. Bystander rule, or the fact that because of the bystander rule, the fact that the employers are supposed to be mere bystanders, they cannot oppose the petition for certification election unless there are requirements that have not been met, like mandatory requirements they forgot to attach in their petition. So unless there are those material lacks in their petition, usually the petition for certification election will be granted. There are no limits in the number of preliminary conferences, but there's a timeline limit with respect to that. So after the hearings, the petition for certification election from the date of the preliminary conference, and then within 10 days from the date of the last hearing, a decision should be rendered on the petition for certification election. So that's the time when the petition or denied. Or less, if again, comply with the documentary requirements and other substantial requirements for filing a petition, then the petition will likely be and almost always granted. Once it's granted, the case will be raffled to an election officer within 24 hours from the notice of entry of final judgment, which is the grant of the certification election. And then after that, within 10 days from the receipt of the election officer, pre-election conferences will be held. So the pre-election conferences will be attended by the management again and the union. During the conferences, the schedule of the election will be finalized, the place or the venue and the time, the date, and then they will also decide on the list of eligible voters during the election. So this is the time when they will finally decide on the coverage of the bargaining unit and which employees are supposed to be covered in the bargaining unit. So this is the time that the employee, that the union and the management will agree on whether or not to exclude certain rank and file employees or certain supervisory employees, or whether or not to include them in the bargaining unit. There are also no limit as to the number of pre-election conferences which may be held, but there is also a timeline by which Dole should be bound. So not later than 45 days from the date of the first pre-election conference, the certification must be held. But of course, even with this timeline, if there are certain delays that are warranted under the circumstances, then this may be stretched and the certification election may be delayed and scheduled at a later time. So usually during pre-election conferences, if the management and the union cannot decide with finality the venue or the time and the date, or maybe and usually on the list of eligible voters, that's a valid cause for delay. It's not working. It's not here. Okay, so the third mode is through consent elections. Actually, consent elections is like a variant of the certification elections. A consent election is done when two or more unions agree on their own to conduct certification election. But of course, a mere informal agreement amongst them or between them will not finalize a certification election. When they after such agreement, they will have to go to the dole and file for a certification election. So it's initiated by two or more unions. So in this consent election, same process goes. The eligible voters will choose between the two or more contending unions, and no, the no union vote is also another option. So what are the rights of a legitimate labor union? So when we say legitimate labor union, this is after the registration with the DOLE. So first, they have the right to act as the representative of their members for the purpose of collective bargaining. Second, they have the right to be certified as the exclusive representative of all the employees in the bargaining unit for purposes of collective bargaining as well. So this is after any of the three modes of certification is done. Third, they can also own property, real or personal, for the use and benefit of the labor organization. And this is because once they have registered, they already acquire a juridical entity. They can also sue and be sued as in its registered name as a juridical entity. And they also have the right to demand from the management annual audited financial statements. So, of course, the union will do this if, especially when they have already been certified as a bargaining representative of the employees in the bargaining unit. Because for purposes of collective bargaining negotiations, they would want to know how much the company is making and how the business is going, so that they can have an informed decision as to what kind of proposals they will be offering for purposes of concluding a collective bargaining agreement. And lastly, they have the right to undertake all other activities designed to benefit the organization and its members, including housing, welfare, and other projects. So, corollary to the rights of the labor union, the employer has the following obligations. So, first, they have the obligation to furnish a copy of their annual audited financial statements to the union. because under the law, the union has the right to be furnished such copies. They also have the obligation not to commit any of the prohibited unfair labor practices, which we will discuss later on. And they have an obligation to bargain in good faith with the exclusive bargaining agent or with the labor union. So when you say they have an obligation to bargain in good faith, it means that when they are called for bargaining negotiations by the union, so it means when the union proposes, makes a proposal for the collective bargaining agreement, they have to respond. They have a duty to respond, and they have to have the intent of concluding a collective bargaining agreement and not just keep dodging the proposals of the union. So once the legitimate labor organization has already been certified as the exclusive bargaining agent of the employees in the bargaining unit, either through voluntary recognition, certification election, or consent election, what happens next? So once you're already a certified bargaining agent, you can already engage in collective bargaining negotiations for purposes of arriving at the collective bargaining agreement. So how does the process work? For initiating collective bargaining negotiations, the labor union should serve a written notice to the employer stating the proposals it wants to be included in the collective bargaining agreement. So after that, the company has a duty to reply to the letter containing the proposals within 10 calendar days from receipt of the proposals. Of course, ideally, if they would agree at once, then that's good for, I guess, for both parties because this will not delay anything else, and the employees will already have a collective bargaining agreement to hold on to. However, reality says that collective bargaining negotiations is not as easy as that. So usually there will be differences between the proposals of the union and the counter proposals of the management, and this will require for them to meet. So they are allowed to hold conferences not later than 10 calendar days from the date of the request of either party. So they are allowed to hold conferences to discuss their differences and hopefully arrive at an agreement. So let's say the union proposes a certain amount, the company will propose a counter proposal, and then they will have to maybe arrive at a compromise during the conferences. So parties are not prevented from agreeing on the number of conferences it may hold to discuss the union's proposal and the management's counter proposal. Normally it takes 4 to 10 conferences, but I think based on experience, it can go beyond 10 conferences. And the 10 conferences will not be confined to a few months. Usually the negotiations would take as long as weeks to months and even a year. So it can take as long as that, as long as there is no agreement between the management and the union. If the dispute or difference is not settled, the NCMB or the National Conciliation and Mediation Board may intervene upon request of either or both parties. So when, let's say, they can't deal with their differences anymore on their own, they may call the NCMB for intervention. So when this happens, both parties, the management and the union, will be called to conciliation meetings or conciliation conferences. And well, actually, the same thing would happen. It's just that the NCMB will be there to facilitate the meetings. But it's all the same that the management and the union will make proposals and counter proposals in order to arrive at a settlement. So when concluded, the CBA should be registered within 30 days from execution. The CBA, let's see. So the CBA, once concluded, it has a life of 5 years. So at least with respect to the representation aspect, that means that the CBA will be effective for 5 years, and the union that is a party to the CBA will be the certified exclusive bargaining agent of the employees for 5 years. So this means that no other petition for certification election may be held within that span of 5 years, except during the freedom period, which I have mentioned earlier, which is the last 60 days of the life of the CBA. during which a petition for certification election may already be filed by another union who also seeks to represent the employees. But with respect to the economic aspects of the CBA, which means, let's say, the compensation and benefits of the employees that are embodied in the CBA, they may be renegotiated within 3 years from the conclusion of the CBA. So with respect to the representation aspect, that's 5 years, but with respect to the economic aspect, that's 3 years. Aside from the right to collectively bargain with the management, the union also has the right to declare strikes. And at the same time, the management has the right to declare a lockout. So, what are strikes and what are lockouts? A strike is any temporary stoppage of work by the concerted action of the employees as a result of an industrial or labor dispute. So, I'm sure everyone's familiar with that. Um, there have been several cases of employee strikes that have been over the news for the past few years. Um, Meanwhile, lockout is any temporary stoppage of operations by the decision of management as a result of an industrial or labor dispute. Actually, the grounds for the strike, for a strike or a lockout, are the same. Um, so for declaring a strike or a lockout, there are requirements. They can't just go on a strike. Let's say they have decided to go on a strike today, they can go on a strike tomorrow. There are requirements that they have to fulfill. And if they do not fulfill these requirements, then the strike or the lockout may be declared illegal. So what are the requirements? First, the strike or the lockout must be based on a valid and factual ground. So what would be considered a valid and a factual ground? Strikes and lockouts may only be declared on account of a ULP or an unfair labor practice or a deadlock in the negotiation of a collective bargaining agreement. So if the grounds for declaring a strike or a lockout does not fall under any of these two, then it will be considered as illegal. Second, once there is already a valid and factual ground for the strike or the lockout, then a notice of strike or lockout should be filed with the DOLE. So it's not a mere declaration within or among the union members or within the premises of the establishment. They also have to involve the DOLE in the conduct of a strike or a lockout. Aside from the notice, they should also observe the cooling off period. So what is this cooling off period? So the notice of strike or the notice of lockout should be filed 30 days before the actual conduct of the strike or actual implementation of a lockout. So this means that after filing of the notice, they have to maintain status quo for 30 days. And after that period of 30 days, that's the only time that they can declare or conduct a strike or the lockout. For purposes of declaring or conducting a strike or a lockout on the ground of an unfair labor practice, the 30 days may be reduced to 15 days. And meanwhile, if there is an allegation of union busting, so this is in case of a notice of strike, if there is an allegation of union busting by the employer that is alleged by the union, then they may have grounds not to observe the cooling period and declare the strike at once. Aside from that, the strike or the lockout should be supported by a majority vote of either the members of the union in case of strike and the board of directors of the management in case of a lockout. So how does this work? So when you file the notice, after that, and at least 7 days before the intended date of the strike, uh, a vote, a casting of the votes should be done, which may or may not be attended to by the labor agencies. Um, and if they have the majority vote, then they should report that the results of the voting to the DOLE so that they can substantiate their declaration of the strike or the lockout. And the last requirement is that the dispute must not be the subject of an assumption of jurisdiction, a certification for compulsory arbitration, or submission to compulsory or voluntary arbitration, or a subject of a pending case involving the same grounds for the strike or lockout. So if this is already under the jurisdiction of the labor agencies, then it may not already be the subject of a strike or a lockout. So for the grievance machinery, actually, it's not necessary that there is a union or that the establishment is organized before a grievance machinery may be implemented. So a grievance machinery is primarily for for the implementation or interpretation of a CVA in case of an organized establishment, and including those establishments that are not organized, also for the interpretation or enforcement of company policies. So there are establishments that have grievance machineries even if they don't have a legitimate labor organization or a certified bargaining agent in the for the specific bargaining unit. What does a grievance machinery do? So a grievance machinery, it's supposed to lay down the procedure on how grievances should be dealt with by the management and the union, for instance. So it provides for a procedure. For instance, if there's a complaint from the union, they will file it with the management, and then there will be conferences that will be held in order to resolve the grievances. And then after that, if it's resolved, then um, they go back to where they were. But if the grievances are not resolved, they may elevate it to voluntary arbitration, which is under the jurisdiction of the National Conciliation and Mediation Board. For the labor management councils, these are actually alternatives. Actually, this can be proposed as an alternative to unionization or forming a union in the establishment. So, what is a labor management council? It's actually it's like a committee or a council that is composed of representatives from the management and representatives from the employees. So they form a committee in order to formulate policies or make decisions that will affect the welfare or the benefits and the rights of the employees. So this way, um, employees will actually not need to have a union because in labor management councils they already have representatives that will voice out their concerns to the management, and then that will help them to formulate policies that will be beneficial to them. As I mentioned earlier, the, one of the grounds for the declaration of strike and lockout is unfair labor practices, and it is also an obligation on the part of the employer. At the same time, an obligation on the part of the labor organization not to commit unfair labor practices. But for this part, let us focus on unfair labor practices that are committed by the employer. What are the unfair labor practices that may be committed by an employer? First is interference. So it is when an employer interferes with or coerces an employee with respect to the right of the employee to self-organization. So for example, if the employer, let's say the management, um, threatens the employee to not join the union or to not form a union, then that may be considered an unfair labor practice. Number two is the yellow dog condition. So this is when the employer requires as a condition for employment that an employee or a person shall not join a labor organization or shall withdraw from the membership to a labor organization. So it's like if you want to be hired, you should not have any membership in a labor union. So that's also an unfair labor practice. Number three is contracting out, or when the employer contracts out services or functions being performed by union members, which will interfere with or coerce employees in the exercise of their rights to self-organization. So it's also like a threat to the employees, such that if they continue to if they continue to form a union or to join a union, then they will contract out the services to other contractors or to a third party contractor. The next one is company unionism. So this is when the company or the employer dominates or assists with the formation of or administration of a labor organization. So I've mentioned this earlier when I was discussing the voluntary recognition of the employer. So this is when the employer actually initiates the formation of a union that will protect its own interests and not the interests of the employees. Next is discrimination for or against union membership. So this is when the employer, let's say, gives more benefits or gives more compensation to those employees who are not members of the union and gives less to those who are members of the union. So that is a very clear discrimination when, in fact, all these employees are of the same rank, of the same position, and do the same job. So that is also an unfair labor practice. Next is discrimination because of testimony. So let's say an employee or a member of a union says something that is against the company, and the company does something that discriminatory to this employee, such as, let's say, dismissal or demotion. So that is clear discrimination just because of what the employee said against the company. Violation of duty to bargain. So as a duty of the employer, the duty of the employer is to bargain in good faith with the union. So if it doesn't fulfill that duty, then that may also be a ground to say that the employer is guilty of an unfair labor practice. Next is paid negotiations. So during the negotiations, let's say the employer pays the union officers who are supposedly representing the employees to arrive at terms of the CBA. And because the employer does not want to grant the proposals of the employees, the employer would just pay off the union officers just to give in to the demands of the employer. And ninth, the gross violation of a CBA. So when you say gross violation of a CBA, this refers to the violation by the employer or non-compliance with the economic provisions of the CBA. So let's say the salaries of the employees or the other benefits that are supposed to be received by the employees by virtue of the CBA. If the management does not comply with those provisions in the CBA, then those may be considered gross violations, which may constitute unfair labor practice. So for unfair labor practice, for these acts of unfair labor practice, aside from an administrative case which may be filed against the employer before the NLRC, once a decision is made granting the complaint and finding that there has been unfair labor practice committed by the employer, the union may actually initiate criminal charges against the employer for such unfair labor practice acts. So without that administrative finding of unfair labor practice, the criminal proceedings will not be able to proceed. So once a union has been formed, it doesn't mean that that it will live forever. There are ways by which the unions may be dissolved or may be removed from the register. There are two ways. The first one is through a petition for cancellation of registration by any party in interest, and the second is through voluntary dissolution by the members of the union itself. So for the petition for cancellation of registration, this may be filed by any party in interest, and there are only two grounds by which this may be done. First is based on misrepresentation, false statement, or fraud in the ratification of the Constitution and the bylaws of the Union. Second is on misrepresentation, false statement, or fraud with respect to the election of officers. So these are the only limited grounds in filing for a petition for cancellation of registration. Also, the petition for cancellation of registration should be an independent petition that should be filed. It cannot be filed, or the cancellation of the union cannot be proceeded upon let's say, in a certification election. You cannot ask for the cancellation of a union during in the petition for certification election. Instead, you should file it separately. Second, the voluntary dissolution by the members of the union itself. So the union or the members of the union should be the ones to apply for the dissolution, but it requires 2/3 of all the members and should be attested to by the union president in order for the application to be validly filed. So it's easier, as you can see, given the numbers required, it's easier to form a union and register a union as opposed to dissolving a union. Okay, so those are the existing laws right now with respect to the formation, the registration, the certification as exclusive bargaining agent, and the dissolution of labor organizations. Because of the workers' right to self-organization that is embodied in the Constitution, there are legislators who are pushing for further rights for the employees. One is through Senate Bill 1169 and the Workers' Rights to Self-Organization. So I believe this has been passed by Senator Joel Villanueva. So this bill, it seeks to lower the minimum membership requirement for independent registration, which we have discussed earlier, from the current 20% membership to 5% of all members of the bargaining unit. So you see the drastic decrease in the minimum membership requirement for purposes of independently registering. It also seeks to lower the minimum requirement for registration from 10 to 5 local chapters. This is with respect to national federations. So as it stands now, national federations should be able to show that they have 10 local chapters in order to be registered. But this bill, it seeks to lower this number into only 5 local chapters. This bill also seeks to implement an online registration process for labor unions and federations, and it also seeks to deregulate foreign participation in trade union activities. So, just I guess my 2 cents with respect to this bill. I guess this will really foster and maybe further the right to self-organization of workers. However, this may also pose complications. As it stands now, it's actually easy to register as a union, if not by virtue of an independent registration, because that would require you 20% of the union membership. It's easy to affiliate with a federation and have them issue you a charter certificate. And by virtue of that charter certificate, you're already able to register as a union. So you don't need the 20% requirement. So lowering the minimum membership requirement to 5% may actually defeat that option for the unions, because ultimately after the registration they will have to undergo certification election, and if they are not able to show that they have the support of most of the members of their bargaining unit, then there's a likely chance that they will not win the elections. So I think 20% minimum requirement for registration is actually aimed at ensuring that the members of the bargaining unit, which the union seeks to represent, actually support the formation of the union, and they actually more or less want to be represented by that labor organization. With respect to the online registration process, I think this is a good idea, but I think this does not only apply with respect to the registration of labor unions and federations. I think they should also apply to other registration processes in the government in general, because it will make the lives of all Filipinos so much easier if we do online registration processes for most of the things that we need to do with the government. Next bill is House Bill 4446, which also seeks to strengthen the right to self-organization. This was filed by TUCP Representative Raymond Mendoza, who actually filed a lot of other bills in Congress. with respect to the rights of workers to self-organization. So first, the bill seeks to impose heavier penalties for the commission of unfair labor practices by employers. So earlier, we've discussed that unfair labor practice charges should first be filed with the NLRC, and there should first be an administrative finding that there has been unfair labor practice that was committed by the employer before criminal charges may be filed against the employer for the same unfair labor practices. But with this bill, it seeks to allow the initiation of criminal proceedings at once, even without any administrative finding of unfair labor practices. And it also imposes additional fines concerning commission of unfair labor practices. The bill also seeks to provide for an easier and faster process of certifying labor unions. So this one's interesting because the bill actually seeks to allow the certification of a legitimate labor organization as the exclusive bargaining agent of employees without the benefit of a certification election. So, in this case, the union will be allowed to file a petition for certification election, but if the union is able to show or to submit valid authorizations from the majority of the bargaining unit, then they may be allowed to be certified as the bargaining agent already, even without conducting a certification election. So this may pose some complications and maybe a little be problematic because for one, based on experience, it's easy to garner or to gather signatures from employees in a certain bargaining unit for purposes of petitions. So let's say officers will go around asking employees to sign a piece of paper, a piece of blank paper, and then maybe they can just, after all the signatures have been gathered, they can just write on it for purposes of constituting a valid authorization in order that they may be certified as the exclusive bargaining agent of the bargaining unit. So this may not be an informed decision on the part of the members of the bargaining unit. So I think a certification election is still necessary, and the allowance of the submission of valid authorizations may not be sufficient for purposes of protecting the interests of the employees. Um, Also contained in the bill is that an employer may file a petition for certification election of the union, and in which case the union may already be certified as the exclusive bargaining agent or a certification election may be ordered. However, the bill does not specifically provide the grounds under which a certification election should be ordered versus the automatic certification of the union as the exclusive bargaining agent. So this may be prone to abuse because once there is a petition for certification election, then there is no chance for the employees to choose or to decide whether or not they want that union to represent them. Other bills are House Bills 1354 and 4448. So this one seeks to remove the regulation on foreign participation in trade union activities and enforce the right to self-organization of aliens. So these bills, they seek to allow all foreign nationals to enjoy the right to self-organization regardless of nationality and in disregard of the reciprocity rule. So by way of background, as it currently stands, the law actually allows aliens to um, form unions, join unions, assist unions, and engage in all these trade union activities, provided that they are nationals of countries that also allow Filipinos in such country to exercise the same rights. So that's the reciprocity rule. So this bill it disregards the reciprocity rule and allows in general all aliens, regardless of nationality, to exercise that right. This bill also allows foreign entities to give donations, grants, or other forms of assistance to any labor organization in relation to trade union activities without the need to secure permission from the DOLE. So currently, this is regulated in that they would need the permission from the Secretary of Labor and Employment before the donations, grants, or other forms of assistance may be given. So by virtue of this bill, such permission from the Secretary of Labor and Employment would not be needed. I think with respect to the first provision, or um, the first amendment that is sought by these House bills, I think there is the idea that the reciprocity rule is also meant to protect Filipinos that are abroad. So I think if you can imagine that we grant all aliens or all foreigners the right to self-organization in this country, but our fellow Filipinos in other countries are not granted the same rights. So I think this also seeks to further the interest of all Filipinos who are not in the country. Second, I think the Second Amendment with respect to donations, grants, and other forms of assistance, I think this seeks to minimize the interference by foreign entities, and that's why they need the permission of the Secretary of Labor and Employment. So it makes it difficult for them to, or it makes it difficult for foreign entities to interfere with trade union activities in the country. But if this bill gets approved, then it's a free flow for everybody, and there may be some complications with respect to foreign entities interfering with trade union activities, particularly with respect to the formation of unions and the activities of the unions in the country. The next one is House Bill 4445, which pertains to the right to self-organization of cooperative members. So this bill seeks to grant cooperative members the right to self-organization, which is the right to form a union for purposes of collective bargaining agreement. This has also been passed by TUCP Representative Mendoza. Um, Currently, cooperative members are not allowed um, to form unions for purposes of collective bargaining. Only cooperative employees who are not members are allowed to exercise that right. But for purposes of cooperative members, they actually have the right to form a union for their mutual aid and protection, but not for purposes of collective bargaining. In a Supreme Court decision that was decided, the rationale behind the disallowance of cooperative members to right to self-organization is that cooperative members are actually owners of the cooperative. So if they are allowed the right to self-organization, or they given the right to self-organization, they are allowed to form a union, they will form a union as supposedly employees, and their employers are actually the cooperatives that they actually own. So there is a conflict of interest, and it does not meet reason how an owner of a cooperative can be a union member when that cooperative is actually owned by the union member. Finally, House Bill 4447, which strengthens the right of employees to strike. The bill seeks to allow the filing of a notice of strike by any group of workers or legitimate representatives of workers versus how it stands now, that only legitimate labor organizations may file a notice of strike in case of an alleged unfair labor practice committed by the employer. It also seeks to downgrade the penalty for union officers' participation in illegal strike and commission of illegal acts by non-union officers during an illegal strike from dismissal to mere disciplinary action. Um, for the filing of a notice of strike, I think it is only reasonable for the law to require that only legitimate labor organizations may file a notice of strike. Because assuming that there is an ongoing dispute between the management and a union, allowing, let's say, a non-union member who is considered a legitimate representative of workers to interfere and file a notice of strike may be complicated because, for one, that person, legitimate representative of workers, may not even have the standing to interfere with the ongoing negotiations, for instance. So this may be an issue of whether or not um, the one who will file the notice of strike actually has an interest at stake, um, that may allow him to actually interfere with the ongoing negotiations between the management and the union. With respect to downgrading the penalty for union officers' participation in illegal strike and commission of illegal acts from dismissal, as it currently stands, to mere disciplinary action, I think the penalty of dismissal is actually implemented to discourage employees who are non-union officers and employees who are union officers to actually engage in illegal activities during the strike. So this is more of a protection for the interest of the general um, the general population of the employees. Because if there will be a downgrade in penalty, this may embolden the union officers to keep participating in illegal strikes, and non-union officers who are union members to participate in illegal activities during the strike. In fact, I think as it currently stands in a Supreme Court decision in 2009, um, it has been clarified that the penalty of dismissal will only be implemented if the participation the union officers is actually knowing. So there must be an intent to participate in a legal strike. So that in itself, I think that qualification already limits the imposition of dismissal, and which cannot be considered a harsh penalty for such participation.
Okay, so that's for our discussion. So, Attorney Ro, why is collective bargaining important for business?
Well, collective bargaining is important for the business. So I'm assuming you're asking from the perspective of an lawyer. Collective bargaining may be important insofar as the employer is already able to foresee how the business is going to work for, let's say, 3 to 5 years. So they can already predict, they can already prepare their budget for for the benefits that they need to provide to the employees as contained in the CBA. They could already foresee how it's going to work in the future. But primarily, CBAs are for the benefit of the employees. So, if at all, the benefit of the employer in such CBAs is that they can prepare and they can control, at the very least, what they agree on during the collective bargaining negotiations.
Okay. How can companies uphold the right to collective bargaining?
How can companies uphold the right to collective bargaining? Um, I think corollary to the right of the union to initiate collective bargaining negotiations, the management on its part has the duty to bargain collectively, to bargain in good faith. So, upholding the right to collective bargaining means engaging in the collective bargaining negotiations in good faith, and actually having the intention of arriving at an agreement that will be embodied in the collective bargaining agreements.
Okay. What if the employer refused to have the collective bargaining negotiations?
Hmm. Are you asking about the legal implications of that?
Yes.
Okay. That will actually be considered an unfair labor practice. So, as I've discussed earlier, one of the acts that constitute unfair labor practice is the violation of the duty to bargain. So, if the employer refuses to engage in collective bargaining negotiations, then the union may actually um, file a notice of strike, may file a complaint before the NLRC, and complain of unfair labor practice.
Okay. Does the employer have to recognize and negotiate with each union that wants to organize their workers?
Oh, no, definitely not. That's why when I discussed with you earlier, before a union is actually entitled to collective bargaining negotiations with the management, the union must first one register, so that it will be considered a legitimate labor union. Second, it has to be certified as the exclusive bargaining agent of employees. So there can only be one union that can be certified as the exclusive bargaining agent of employees within a bargaining unit. So that one exclusive bargaining agent is the only one who has the right to demand collective bargaining negotiations with the management.
Does contractual or job order employee of government or private institutions have their right for self-organization? Or for government first?
For government, I think for government they have the right for self organization, but not for
The
purposes
contractual or job order employees.
contractual or
Yeah.
job order employees. Yes, they have it, but it's not for purposes of collective bargaining. So it's different kasi with the government and with the private sector. With the government, they can form unions, but only for mutual aid and protection. So they actually can't bargain the government. Government, give us
Yeah.
more, give us higher salaries. Because it's a government who will decide. They cannot bargain for that. But for the private sector, they can do that.
Can we have several union groups under one organization?
By one organization, I think you mean one establishment.
Yes.
Yes, actually, you can have one union or one labor organization per bargaining unit. So, for example, rank and file employees in the production, let's say it's a manufacturing company. Rank and file employees in the production can have one union. Supervisory employees in the production can have another union. Rank and file employees in the HR can have another union. So, as many as there are bargaining units, there can be that many unions in the establishment.
If only one organization registered, will they be automatically authorized exclusively?
Oh no. So the registration process with the DOLE is a separate process, and the certification as the exclusive bargaining agent is another process. So preliminarily, the labor union should be able to register first before it can actually be certified as an exclusive bargaining agent. So the certification as an exclusive bargaining agent will happen if there is one voluntary recognition by the employer, or two if there's a if it wins in a certification election. So once registered, you're not an automatic bargaining agent. You have to undergo election or recognition by the employer.
Okay. What does it mean to bargain in good faith?
Okay, to bargain in good faith means um, you are not bargaining for purposes just so you can say na, oh, I talked to you ha, or we discussed your proposals ha. Bargaining in good faith means you actually have the intention of concluding the CBA. So you have the intention of giving them what they want, maybe not exactly what they want, but giving them something that will benefit them.
At what levels should collective bargaining take place?
At what level should collective bargaining take place? What does that mean?
Or do the ILO or the ILS provide guidance on whether wages should be the subject of negotiations? Do you have an overview of best practices by companies?
Wages are usually, almost always, actually always, wages are always subject of collective bargaining negotiations. I think it is the primary consideration in making proposals. So usually unions would bargain for higher wage, number one. Number two, regular salary increases, like yearly salary increases. So that's what they usually bargain for. Other than wages, they also bargain for additional benefits such as HMO coverage or meal allowances, OT meal allowances, things like that. But primarily, it's about the money, their take-home pay.
What information should be shared with workers' representatives for negotiations and collective bargaining?
What? Sorry again.
What information should be shared with workers' representatives?
Um, you mean from the part of the management?
Yes.
Um, Well, not voluntarily, but workers' representatives or the union officers would usually demand the management to give them a copy of their annual audited financial statements. So the management, once the union makes that request, the management has the duty to furnish them a copy of the AFS within calendar days from the 30 calendar days from the date of the request. So based on the AFS, the audited statements, the union officers may then have an informed decision as to what kind or how much increases or how or which benefits they would demand from the management based on information on profits or how good the business is doing.
Okay, so what subjects can be covered by collective bargaining?
Um, any subject actually. So the parties, the management, and the union will are free to negotiate on all aspects of employment. So all terms and conditions of employment, including wages, work schedule, flexibility in time schedule, work shifts,
So anything work related.
anything, all the terms and conditions of employment.
Okay. So I think this is the last question, Attorney Ru. Are managers or members of the management can be form part of the union?
No, they cannot. So managerial employees cannot form, cannot assist, cannot join unions. That's because managerial employees are supposed to be on the side of the management. So they're supposed to look after the interests of the employer. If they join a union, they will have a conflict of interest because their personal interest as an employee will, of course, be prioritized over the interest of of the employer.
Okay, attorney, may pahabol po siya. Can employees or members of an agency or cooperative, do they have the right to self-organize? Member of the cooperative.
Cooperatives. Okay. Cooperative members specifically, they have the right to organize, but not for purposes of collective bargaining. So they can only organize for mutual aid and mutual aid and protection like the government employees. But for cooperative employees, which is different from cooperative members, they can organize for purposes of collective bargaining. So just to distinguish, the cooperative members are actually the owners of the cooperative, while the cooperative employees are employees of that cooperative. So basically, the cooperative employees, boss nila yung cooperative members. Habol ba?
Do you have a percent or estimate number of BPO companies that are unionized?
BPO companies, based on experience, very minimal percentage. Siguro I would put it at 10% of the BPO companies are unionized. Based on experience, that's based on my clientele, ha. So I'm not exactly sure with respect to other BPO companies.
Okay, I think wala tayong questions. Okay, so thank you, Attorney Ro,
Thank
for
you.
discussing the employees' right to self-organization. So everyone, if you want updates on our upcoming events, you may like our Facebook page, www.facebook.com/pmap1956, or visit our website, www.pmap.org.ph. That's it. So good afternoon, everyone. Thank you.
Thanks, everybody.